Mark Rosen.
I'm going to say some overlapping things, actually. Okay, so very quickly, two quick constitutional issues, not necessarily the most pressing also, but that occurred to me. One is more connected with the Trump candidacy, and that is the Electoral College. And the irony, this is an issue that Professor Shapiro knows much about, but that the institution that was there to check against excesses of popular expression no longer serves that function, and instead just distorts the popular vote. That seems to be extremely problematic and wrong-headed, and that's an issue that's present and problematic. Again, for electors to be who might not elect as cast ballots in accord with what their states decided to be termed faithless electors undermines what the Electoral College was really supposed to do in the first place. First point. Second point, which is very similar to, in some ways thematically, to Dean Krentz, is I've been thinking, actually partly due to conversations with a student who's present here today, about the nature of the president's take care clause powers. And let me just get into it a little bit. What does the president do? I mean, he represents the United States, but a lot of people aren't really attentive to some of the most important functions of his or hers, which is to execute the law. And in my experience, a lot of Americans, a lot of law students, they have an intuition about how important the legislature is that creates the laws and the courts, but they don't really have a sense, to execute the law. And the thing is that everybody intuitively understands that. I think, if you just have law in the books, that doesn't mean anything. It really does have to be enforced. As I tell my students, 45 miles per hour on Lakeshore Drive, or whatever it's posted, is not really what the law is.
75 miles.
Except for those occasions that
except
you
when
get.
you see the police officer.
Yes. And so, one of the president's primary functions is under the Take Care Clause to take care of the laws faithfully executed. And what exactly does that mean? It's surprisingly sort of untheorized and unanswered. There's a lot of people have given some attention, although not the courts, to issues of under-enforcement. The issue came up under President Obama with the DAPA program, for example. Those are real issues. But the United States Supreme Court, very recently, with the DAPA controversy, refused to confront the Take Care Clause question of whether, less than avid enforcement by the executive is an abrogation of the Take Clause responsibility. That's kind of interesting. That's a question I want to think about, but I also want to talk about its. Think about its coordinate question, which is there any concept or any room to think that there might be something problematic about over-enforcement of law? If tremendous number of resources were directed by the president just to enforce a handful of laws, might that be problematic? Not what taking care that laws be faithfully executed means. There's virtually actually no discussion I've seen about that. But what I want to do is just throw out two quick ideas as to why there might be some legs to that idea. If you think back, for example, to the Morrison v. Olson opinion, that was the opinion of the Supreme Court that upheld the Independent Counsel Act. There's a very famous Justice Scalia dissent. He thought the act was unconstitutional. The main argument he gave, it's very interesting, was essentially that an independent prosecutor will spend all his or her resources just directed at one individual and just to trip them up. And one of his points was that there's inherent discretion that ought to be executed by prosecutors that isn't by virtue of the Independent Counsel Act. And most people think, myself included, that there was really something to Justice Scalia's point, if not his methodology for his constitutional conclusion. But that point presumes that there could be something wrongful about, over-enforcing the law. Also, you think back to Poe v. Ullman, there's other cases like it. It was a pre-Roe v. Wade case that, I'll be done in a moment, that that held that there was no standing to challenge the Connecticut's statute that barred the use of contraceptive devices because the court noted the Connecticut authorities had not enforced the statute, and the court actually observed. Now this was state officials, but this non-enforcement, not in a critical way. Like there's something, perhaps to to not over-enforcing, under-enforcing. That's appropriate to the executive function. So that's actually an issue that the appropriate scope of the take care clause. It's an issue that I've been thinking about, and just to tell you, I don't think it's ultimately an issue that ought to be decided by courts, but I think it's an issue that the executive ought to seriously think about. And there's not much thought about that's happened to this point. But here's the great takeaway. The president, everybody should recognize now, if they didn't understand before, has extraordinary discretion in determining how he or she is going to enforce the laws. And that's an awesome power that that can be overlooked by us who focus on courts and legislatures, but it is an awesome power that is now wielded by